Hi, today we have an interesting question about discharging taxes in a Chapter 7 bankruptcy. And the question goes like this. I want to file a Chapter 7. I'm certain the IRS debt will be discharged, but how can I get the lien lifted? My name's Darrin Mish. I'm a tax attorney from Tampa, Florida, and we also do bankruptcies for tax cases for the local Middle District of Florida area. We deal with this issue quite a bit. The questioner has some further facts that I'm going to go ahead and read here. It says, I have an IRS lien that is attached to a house underwater that the bank is taking in a couple of months after foreclosure judgment. I do not have any assets of value, so the IRS will not receive any compensation in a Chapter 7 bankruptcy. I am 100% sure the old taxes will be discharged in bankruptcy. Will the lien automatically be lifted upon discharge? If not, what do I have to do to get the lien lifted? And can the lien be applied to newly acquired future property after bankruptcy, even though what I owe the IRS was discharged in the bankruptcy? That's really a fact-specific question, but I'm going to do my best to go ahead and give you a good answer. So, before we can talk about the lien, I think we should probably talk about the dischargeability rules, the timing dischargeability rules in bankruptcy. So there's three basic rules. The first is the returns have to have been due for at least 3 years, including extensions. So remember, tax returns are due April 15th, the year following the tax year in question. So for our 2013 tax return, they're going to be due on April 15th, sometimes 16th or 17th of 2014. Now, if there was extensions, the automatic extension nowadays is until October 15th or sometimes 16th or 17th, depending on if it falls on a weekend. And so then you would have to wait 3 years from the extension date to meet this timing rule if you filed an extension, even if you filed before the extension was up. The second rule is you have to have filed the returns if filed late for at least 2 years. Now that's the law in most jurisdictions. Now there's a case out there called McCoy that's really super poorly reasoned that stands for the proposition that if you file the return late at all, then it's not a tax return and it can never be discharged in a bankruptcy. Fortunately, in Florida, in the Middle District of Florida, we don't have that problem yet. I think that the McCoy case is primarily out of the Fifth Circuit, and so people in the Fifth Circuit just have to know that, just have to deal with it. I think that the McCoy case will eventually be overturned because the case actually disagrees with the statute, and that isn't usually the way the law works out. I think in the McCoy case, the court really just didn't want a discharge to happen for this particular taxpayer, and so they reasoned in that fashion. Now, the third timing rule is actually the taxes have to have been assessed for at least 240 days. And that's only 8 months or so, and that's usually not the actual timing rule that people have the most time with or trouble with. So let's get back to this particular question. He says he's 100% sure the old taxes will be discharged in bankruptcy. Will the lien automatically be lifted upon discharge? Probably not. Your bankruptcy attorney probably will need to make a phone call and talk to the lien desk or the bankruptcy insolvency unit in your particular district and bring this to their attention. And the IRS employees there will most likely go ahead and lift the lien. The basic rule is if there's no equity in that house at the time of the filing of the petition, then the tax lien does not attach to the post-petition equity that may accrue in that asset. So in English, what that means is that if you filed a petition and there was no equity, and then theoretically 6 months later there was another real estate boom and you had $100,000 equity, the lien doesn't attach to that post-petition equity. So you're going to get off there most likely. I'm not going to go ahead and address what's going to happen in the foreclosure judgment. That's a totally different issue. And to answer your question, no, the lien does not apply to after acquired property. Since there's no assets and there was no equity in the house, you're probably going to get that lien released. You just have to have your bankruptcy attorney call the insolvency unit, the bankruptcy unit in your district, and probably get it taken care of. My name's Darrin Mish. I appreciate you tuning in. You may visit our website at getirshelpnow.com or give us a call at 888-438-6474. Take care.